Question 7. An order temporarily releasing a child to a non-respondent parent or temporarily placing a child with a relative or other suitable person, or remanding or placing a child with a blank to reside with relatives, suitable persons, foster parents, may not be granted unless the person who the child is to be released, remanded, or placed blank of the court with respect to child.
And the answer is an order temporarily releasing the child to a non-respondent, or temporarily placing the child with a relative or suitable person, or remanding or placing the child with the local commissioner of social services may not be granted unless the person who the child is to be released to consents to jurisdiction. Actually, it submits to jurisdiction of the court.
With respect to the child.
With respect. 8. This is 1022. Family court may enter an order directing the temporary removal of a child from his home before a petition is filed if A, the parent or PLR is absent, or the parent was asked and refused to consent to the temporary removal of the child and was informed of the intent to apply for an order under this section and of the information required by section 1023, or B, child appears to suffer from abuse or neglect of his parent or PLR, that his immediate removal is necessary to avoid imminent danger to the child's life or health, and C, there is not enough time to file the petition and hold the preliminary hearing.
And the answer to this is that you need all three of these things to be true. You need that the parent or PLR is absent or present and asked and refused to consent to the removal and was informed of an intent to apply for 1022 order and the information required by 1023, and the child appears to suffer from the abuse or neglect of his parent or PLR, that his immediate removal is necessary to avoid imminent danger to the child's life or health, and there is not enough time to file the petition and hold the 1027 hearing.
And any written order pursuant to this section, the preliminary orders, shall be issued
immediately.
But in no event later than?
Is it the next day? The next court day?
The next court day following the removal of the child.
Yes, okay. 1023, procedure for issuance of temporary order. Any person who may originate a proceeding under Article 10 may apply for, or the court sua sponte may order, an order of temporary removal pursuant to 1022 or 1027, or an order for the provisions of services or assistance, including emergency, medical, or surgical procedures pursuant to 1022, or a temporary order of protection pursuant to 1029. The applicant, or where designated by the court, any appropriate person, shall make every reasonable effort with due regard for necessity of immediate protective action to inform the parent or other PLR of this list. And I'm going to give a list, and it's a list of 5 things of what has to be informed. 1, intent to apply. 2, date and time of application. 3, it's a list of 5 things. 1, the intent to apply for such an order. 2, date and time the application will be made. 3, the address of the court where the application will be made. 4, the right of the person to be present. 5, the right of such person to get counsel if indigent. Well, the right to have counsel and to have counsel assigned if they're indigent. So it's a list of 5 things that they have to notify. 27, question 9. In any case where the child has been removed without a court order, or where there has been a hearing, 1022, removing child before filing of the petition, at which the respondent was not present, or was present but not represented by counsel and did not waive his right to counsel, the family court shall hold a hearing no later than blank after filing of a petition to
The next court date.
Yes, to determine whether the child's interests require protection, including whether the child should be returned to the parent or PLR pending a final order of disposition, and shall continue on successive court days, if necessary, until a decision is made by the court. 3. In any case where the child has not been removed from a parent's PLR, any person originating a proceeding under this article or the child's attorney may apply for, or the court sua sponte may order, a hearing at any time after a petition is filed. The hearing must be scheduled no later than blank after application for hearing was made.
The next court day.
Yep. To determine whether the child's interests require protection, including whether the child should be removed from his parent PLR pending a final order of disposition.
1028 actually is about the application of the parent or the PLR for a child that was temporarily moved, or upon the application of the child's attorney for an order to return the child, an order returning the child. And the court shall hold a hearing to determine whether the child should be returned, unless there has been a hearing pursuant to 1027 on the removal of the child, at which the parent or PLR was present and had the opportunity to be represented by counsel, or upon good cause shown, and except for good cause shown, such hearing shall be held within blank of the application and shall not be adjourned.
Is it 3 days?
It's 3 court days.
3 court days. Okay, so do you want to read that one with the answer in it one more time?
Yes. Okay. So this is upon the application of a parent or PLR for a child temporarily removed, or upon the application of the child's attorney for an order of returning the child. The court shall hold a hearing to determine whether the child should be returned, unless there has been a hearing pursuant to 1027 on the removal of the child, at which the parent or PLR was present and had the opportunity to be represented by counsel, or upon good cause shown. And that hearing shall be held within 3 court days of the application and shall not be adjourned except for good cause shown. Okay. And such hearing, I'm sorry, there was one other thing, but I don't know if you want to put this. Upon such hearing, the court shall grant the application unless it finds that the return presents an imminent risk to the child's health or life. Who may originate a proceeding in Article 10, Child Protective?
Either a child protective agency or a person on the court's direction. Only 2 people. You'll remember, it's only 2.
Yeah, I got to put that in my video of who can originate each article.
This is a relatively new section, so I'm adding it. This is 1028-A, application of a relative to become a foster parent. Upon the application of a relative to become a foster parent of a child in foster care, the court shall hold a hearing to determine whether a child should be placed with such relative. The hearing shall only be held if 1. The relative is related within the 3rd degree of consanguinity to either parent, so not to the child, to either parent. 2. The child has been temporarily removed under this part or placed pursuant to 1055 and placed in non-relative foster care. 3. The relative indicates a willingness to become a foster parent and has not refused previously to be considered as foster parent or custodian of the child, provided, however, that an inability to provide immediate care due to lack of provided, however, that an inability to immediately start taking care of the child due to a lack of resources or inadequate housing, educational, or other arrangements necessary to provide care shall not constitute a previous refusal. 4. The local social services district has refused to place the child with the relative for reasons other than the relative's failure to qualify as a foster parent pursuant to the regulations of OCFS. And 5. The application is brought within 6 months from the date the relative received notice that the child was being removed or had been removed from his home, and no later than 12 months from the date that the child was removed. So again, you need all 5 of these things to be true, and the time rule is in the last one. Brought within 6 months from the date the relative either received notice. So it's 6 months from when the relative received notice, but no more than 12 months from the date the child was removed. So if the child was removed and it took over a year to notify the relative, that's not good enough. Still recording.
1033B. At the initial appearance, the court shall appoint blank to represent the interest of the child named in the petition,
An attorney.
who is alleged to be abused or neglected unless the attorney has already been appointed for such child. Also, at the initial appearance, the court shall advise the respondent of the allegations in the petition and advise the respondent of the right to adjournment in order to obtain counsel. Also, at the initial appearance, the court shall appoint counsel for indigent respondents. Also, at the initial appearance, in cases where child has been removed, the court shall advise the respondent of the right to a hearing. And for the return of the child, and hearing may be requested at any time during the proceeding. Also, at the initial appearance, the court shall require the child protective agency, whether such agency intend to prove that the child is severely or repeatedly abused by blank evidence.
Clear and convincing evidence.
Right. Where the agency advises that it intends to submit such proof, the court shall so advise the respondent. Okay, so it was clear and convincing when it's severely or repeatedly abused.
Yes, and if it's just neglect, it's preponderance.